Today, we'll talk about some of the focus areas of the book revolving around corporate governance. First, we'll discuss directors' responsibilities and liabilities. Secondly, members' rights and remedies. Third, corporate liabilities under Section 17A of the Malaysian Anti-Corruption Commission Act 2009, in short, the MACC Act. Next is corporate rescue mechanisms. And lastly, we'll have a Q&A section as the last segment. Without further ado, let's go straight to our first segment, corporate governance. I have a question for both panelists. The book that you authored is all about corporate governance, which is a system of rules, responsibilities, and procedures on handling corporate matters within a company. Can you tell us what is the importance of good corporate governance on the development of corporations in view of the COVID-19 pandemic? Mr. Gan, would you like to go first?
Well, Amanda, very good afternoon to everyone. Amanda, I think to this question, I will put it in this way. In fact, at all times, corporate governance is crucial, and in fact, it should be the cornerstone of the management of any corporations. I would therefore say that it is even more so significant in the midst of a COVID-19 pandemic crisis. This is because corporate governance aims to promote corporate responsibility in the management of the corporation's affairs. So because corporate governance upholds ethical conduct and transparency, it gives confidence to all relevant stakeholders of corporations. And gaining confidence from all stakeholders is what corporations need at this challenging time in order to emerge stronger from the aftermath of COVID-19 pandemic crisis. As you all know, the inevitable impact of COVID-19 pandemic on the corporations is that most businesses suffer from financial distress. Creditors are going after the corporations for payments of their debts. Shareholders are taking the directors to task in order to preserve the value of their shares. And the directors, of course, are actively engaging themselves with business partners for ways and means to generate revenues for business survival. So I believe that at the current state of affairs, mutual trust and confidence among all stakeholders should be the key factors in any corporation's plan to reshape their business strategies. The practice of good corporate governance, ladies and gentlemen, will give confidence that the company will be managed properly and transparently. It is in this sense that the corporate governance serves as a fundamental value in corporations' endeavors to restore their business sustainability. So therefore, I think the publication of this book on corporate governance is therefore timely. Joon, what's your view on this?
Hi, good afternoon, everyone. Thanks, Amanda, for the introduction, and thank you, Gan, for starting off with the answer. I'm just going to pick up from where you left off. You mentioned management. You linked corporate governance to good management, and I think in this time of the COVID pandemic, it's been a year. We have seen largely the effects of the pandemic, and what becomes quite stark is the impact it has on the resources of the company. Now, I look at it from two aspects. The first is the impact in respect of manpower resources. The second is in terms of finances, cash flow. Both are going to be strained. Companies that employ foreign workers, expatriate workers, they are going to feel the difficulty in sustaining those employees. You've got all sorts of SOPs put in place for companies to have COVID tests, for example. Speaking from personal experience, different organizations and different trades put in place different SOPs. So in business, we are dealing with various trades with differing SOPs, and all these pose more strains on us in the business world. So the need for proper corporate governance it becomes more stark. Corporate governance will help us get around the difficulties that we face, and as we go along today, you'll see what corporate governance entails and how one can see the need for something that is more bespoke, and it's not a one-size-fits-all process. Yeah, so that's really my take on how important corporate governance has become in this period of time.
Thank you. Thank you. My next question is, if an organization does not have any formal good governance procedure in place, how does it start implementing one? Mr. Fu, do you want to give this a try?
Well, speaking from the fundamentals, essentially, to create proper corporate governance rules and arrangements. This is not something new. There is quite a bit of material out there. The first step probably is to create simple internal policies, such as codes of conduct that sets out the duty of care, skill, and negligence at every level of the organization. If there is a need, you need to engage professionals, particularly when you're dealing with issues on duty of care. The organization and people drafting the internal policies will need to understand what is the level of duty of care expected at each level of the employees. Then with that internal policy, you need to then, of course, put in place a good system of oversight and management. There's no point having policies when you don't observe them. And the only way you can ensure that somebody observes them within the organization is to have oversight. With that, then you need to appoint a competent chair with strong leadership ability and expertise in a particular area of the business to lead this oversight, right? And he will, of course, need to build around him a competent board based on skills. So it really depends on the nature of the trade of each business. If you are in construction, for example, you need people who understand that particular area and the nature of governance that is required for that particular trade. So you then have the chair, you have people around him who are skill-based, and then you need to develop sufficient internal and external training and communications. Because with all these policies that you put in place, and over time, obviously, those policies will be developed, people on the ground need to understand what they are, and it needs to be communicated downwards so that with all these things filtering downwards, it is implemented across the company. Right? That is from the starting of implementation of corporate governance. Perhaps I'll hand it back to Gan.
Thanks for that, Mr. Fu.
Anything to say?
Mr. Gan, do you have any input about implementation of corporate governance?
Okay, I think what Joon Liang just said is very true. And in fact, is what is essentially required of all the corporations in terms of the practical aspect of implementation of corporate governance. But what I would like to add on is that since directors are responsible for the management of corporations, it is the directors that should take initiative to ensure that the implementation of corporate governance within the corporation. Remember, Joon Liang was talking about, someone have to take charge. So I would want to emphasize that it is the board of directors that must take the lead. They must lead by example. And for that purpose, it is elementary that directors must know what their legal duties and obligations are. Only then will directors be able to know the expectation required of them in law and the legal parameters within which they should discharge their responsibilities. So this is where the check and balance will come in. So in this regard, talking about how to start implementing the good governance procedure, I would think that the Malaysian Code on Corporate Governance issued by the Security Commission Malaysia would be a good start for directors and all the relevant stakeholders in the corporations. And we have dealt with it the relevant part in this book that we have authored, and whoever interested can look at that chapters. And in particular, in this Malaysian Code of Corporate Governance issued by the Security Commission in Malaysia, it gives some global principles and internationally recognized practices of corporate governance, which are above and beyond the minimum that is required by statute, regulations, and those prescribed by the Bursa Malaysia. So one, when you refer to that Malaysian code, you can find guidance to assist companies in applying the corporate governance practices. And in there are some exemplary practices which support companies in moving towards greater excellence. So Amanda, just so as you know, directors in fact can get a quick understanding of their powers, duties, and liabilities from chapters 2, 3, and 5 of our book. Thanks.
Thanks for highlighting the importance of directors and members. That's a really nice prelude for our next segment, which is all about directors and members. As we all know that the board of directors in companies have many statutory duties and responsibilities, and in every decision they make, they need to take into account how it will affect their employees, customers, shareholders, and other stakeholders. Taking the perspectives from the previous question, what are the key points that the directors should take note of? Mr. Gan, do you want to give it a try?
Yes, Amanda, thanks for that question. I think in fact, it's very crucial questions. Of course, first and foremost, to me, directors must know that they owe fiduciary duties to the company in performing their function as directors. And arising from these duties, so directors, very important for them to bear in mind that they should exercise their powers only for proper purpose, in good faith and in the best interest of the company, as well as exercising reasonable skill, care, and diligence. And in this regard, therefore, it goes without saying that directors cannot misappropriate the company's funds, properties, and make secret profits. Otherwise, not only will there be criminal liabilities, as you all know, and we can see now what happened in court, directors will also have to account and be ordered to pay back the monies misappropriated or the secret profits made. And other than that, it is also worth to note that for the directors to bear in mind that directors must always avoid possible conflict and even conflict of interest, even the possibility of such conflict. It is very important because directors should not place themselves in a position where their personal interests conflict with that of the corporation interest. And in this regard, the three tests that was applied by our federal court in the Datuk Sai Kecil case could be a useful guidance to all directors. This is very easy. This is known profit rule, known conflict rules, and misuse of trust knowledge rules. Basically, it is to avoid all possibility of conflict of interest. And for that reason, the duty to disclose by directors become very important, very significant. Be it you are the director of a larger company, medium company, or even smaller scale of companies. Section 221 of a Company Act 2016 deal with the extent of the director's duty to disclose. And in fact, a very recent court appeal decision in Delta Pelita Sebakong pointed out that the general rule has always been, when in doubt, disclose. And what is to be disclosed? And the federal court then said that it is common sense that one need only to disclose facts and informations which form the basis of the director's interest to those who are not aware of those information and facts, so that everything will be disclosed and everything will be decided on an even ground matter. So Joon, we have highlight all this in substantial part of our books. Do you have any other key points to highlight?
Yes, Gan, thanks. With all that you have said, I don't think I have very much to add. But since you started off on the legal standpoint, and Amanda, you mentioned shareholders, I think looking at it purely from the legal standpoint, the last people that the directors have got to worry about are probably the shareholders. The predominant interests that they've got to bear in mind as far as directors are concerned are, of course, the interests of the company. That's provided for, that's entrenched in the Companies Act. Now, but in reality, I suppose the converse is true. The people that we've got to worry about the most would be the shareholders, because ultimately, we are looking at the company as a business entity. And if directors do not act in the best interest of the company, invariably the shareholders will be hit. And so when we get into further issues in the course of this webinar, you will see what are the rights of the shareholders. And amongst the rights of the shareholders would be to remove a director. So in a sense, whilst the interest of the company is predominant, and the shareholders would be the last people the director has got to worry about in terms of the law. But I think in reality and in a good number of matters that we've come across, it is the shareholders that ultimately decides who stays on the board and who doesn't. Yeah. That's what I've got to add.
Thank you. It seems to me that a director's role carries extensive burden and liabilities under the law, which may lead to risk-averse in making business decisions. Do you have any pointers for directors and all of us in balancing risk-taking and risk aversion? Mr. Gan, let's go with you.
Well, Amanda, another good practical question from you. So let's look at it this way. As all of us can expect, corporations are here to make profits. So question is, to what extent the directors are allowed to take risks with the company's properties, company funds for that purpose? Now, on one hand, they want to make more profit for the corporation. On the other hand, they have to make sure that they are in compliance of the good governance practice. So how do we balance the risk as your question posed? So to me, in order to safeguard themselves, I think it is important for directors to know about what business judgment rule is. This business judgment rules enables directors to make decisions without fearing that their business decision entail legal liability. And this is what exactly it means is essentially this. There is that the law recognizes that the management decision belongs to directors. And hence the court will not substitute its own decision with that of the directors, or to question the correctness of the management decision, which was made in good faith. Unless, of course, there's element of fraud, breach of duties, and conspiracy. And this business judgment rule is provided and governed by Section 214 of our Companies Act 2016. That rules presumes that the directors act with reasonable care, skill, and diligence if the director first makes the business judgment for a proper purpose and good faith. And second, does not have material personal interest in the subject matter of the business judgment and is informed about the subject matter of the business judgment to the extent that the director reasonably believes to be appropriate under the circumstances. And last, reasonably believes that the business judgment is in the best interest of the company. So when all these are complied with, then the business judgment rules apply. And in that sense, the director would not be held liable. So as you can see, what is more important is what I already say in my previous response to your question. Everything boils down to acting in good faith for the best interest and for good purpose. These are also essential for the directors to bear in mind in order to balance up, the risk taking and also the risk aversions in the discharge of their duty. So in this regard, the federal court decision in the Dato' Ibrahim Petra is another useful point for directors to bear in mind whenever they make this certain decision. Because in that case, the federal court say that in order to determine whether or not a director has breached their fiduciary duties, there are two tests. One is a subjective, one is an objective test. Firstly, the subjective test is the breach of the duty. That will be determined on an assessment of the statement of mind of the director, which is a subjective test, and then the director's own assessment of the company's best interest will then be reviewed objectively by the court in accordance with the standard of an honest and intelligent man. So in a nutshell, directors, in balancing the risk taking, they have to make sure that their decision is honest, made in good faith for the benefit of the company, and which is really important, guided by the judgment of an honest and intelligent man. And of course, in the course of doing things, the directors are entitled to rely on various information given by the staff of the corporation and also by an expert. But having said all this, under our section 2152 of the Companies Act, it is incumbent upon the directors to also exercise their independent assessment in reliance of all those information. So these are a few pointers. And again, Amanda, there are many other pointers which is being discussed in chapter 2 of our book. Yeah, I'll leave it as that. Thank you.
Stay tuned for chapter 2. So I think it wouldn't be an understatement to say that shareholders' interests will have an immediate implication if any of the directors' decisions go wrong, which could be unavoidable no matter how prudent a person is. Nobody is perfect, especially in their present business climate. What are the remedies available for our members when their rights have been compromised? Mr. Fu, what's your opinion on this?
Well, shareholders are typically not in the driver's seat. They don't call the shots as far as the company is concerned. This is done by the board of directors. So in a setup where your shareholders don't sit on the board or don't control or don't have nominee directors on the board, it is not inconceivable that certain decisions made by the board, whether made in good faith, whether made rightly or wrongly, will have an impact on the shareholders' pockets or of their rights, right? Let's put it more generally. So there are remedies provided for in law. We all would have heard about derivative actions. We all would have heard about remedies in oppression. So let me first deal with the first two. Now, as far as the Companies Act 2016 is concerned, we've got section 347 that deals with derivative actions. Now, putting that aside for the moment, the difficulty that I have personally with section 347 is that it does away with common law derivative actions. I know there are good reasons for that to be done, but with statutory derivative action only, there's a requirement for a 30-day notice. Now let's see what the derivative actions are about. It is essentially the shareholders saying that I want to sue in the name of the company, but they are not in a position to drive that because the company is controlled by the board or by the majority of the shareholders. So assuming they then want to bring an action against a director, whether it's for misfeasance, whether it's for a decision that was made negligently, or whether it's in fact for misappropriation of funds. Let's take the last as an example. If there's a misappropriation of funds and you wanted to use the name of the company to sue the director, statutory derivative action as contemplated by section 347 requires you to give a 30-day notice. Now, if the funds have been misappropriated, the last thing you want to do is to tell the person that you want to sue, look, I'll give you 30 days notice that I'm going to commence an action against you. So it doesn't work. Under the old regime, the previous Companies Act, we used to be able to go for common law derivative action and circumvent the 30-day requirement. So in certain circumstances, we can call upon our remedies in oppression, and that's the section just before section 346. So if that misappropriation also falls within the category of an oppressive action, basically an action that is oppressive to one or more of the shareholders of the company or members of the company, then the shareholder can also commence an action in oppression. In that respect, no notice is required, and so an ex parte action, an action by the shareholder without giving notice, can be filed in court, and the necessary injunctions to freeze the accounts or stop the bleeding can be done fairly early on without giving notice to the culpable parties or the parties who are perceived as being culpable. So those are two remedies that are quite often used in oppression. Of course, insofar as both remedies are concerned, there are statutory guidelines. There are requirements that must be met. I don't think that's within the purview of this very short webinar, so I will not delve into that. Quite a number of cases that have dealt with it. I think insofar as oppression is concerned, there was a very recent decision of the federal court in Auspicious Journey, if I'm not mistaken. So that was one of the cases that expand or cast in stone, if I can use those words, the very wide powers of the courts insofar as an oppression action is concerned. Now then I move on to the other remedies that we don't normally consider as remedies because these are not necessarily actions that you take in court. The one very useful remedy is the right to remove a director, right? But that can only happen if you are in a position of control or substantial control. Otherwise, you'll be outvoted. You can in most instances remove a director by ordinary resolution. That's provided for in the Companies Act. And if things, if you come to a situation where things are irretrievable, let's put it that way, then you of course have the remedy to wind up a company, and that's provided for in section 465 of the Companies Act. I think off the top of my head, paragraph F provides for winding up where the affairs of the company has been conducted in the director's own interest rather than in the interest of members. So those are broadly remedies that are available to a shareholder when something goes wrong at the board level.
Thank you, Mr. Fu. We'll move on to our next segment, which is corporate liability and the MACC Act. Since the enforcement of Section 17A on 1st June last year, can one of you tell me whether COVID-19 has affected the implementation of Section 17A? Maybe Mr. Gan, I see that you are ready to answer the question.
Ready to answer the question. Yeah. Amanda, I think the answer really no, because Section 17A continues to be enforced even during this period. Our COVID-19 Act does not provide anything in relation to this part of the MACC Act, and there's also nothing that we heard of that suspend the implementation of the Section 17A. So in fact, it was reported that I think last month, an offshore maintenance company, or maybe just a few weeks ago, was charged under Section 17A of the MACC Act in connection with an alleged bribe committed between 29 June 2020 and 14 October 2020. So this is really the MCO time. So it was says that the alleged bribe was paid to ensure that the company was awarded a subcontract. So this prosecution is not only shows that the MACC commitment in enforcing the corporate liability offences under Section 17A of the MACC Act, it also serves as a timely reminder for corporations to take immediate steps to put in place an adequate preventive measure, which is the only statutory defense available. And for that reason, Chapter 3 of our book is all about the corporate liability under Section 17A of the MACC Act and the all matters in relation to the statutory defense of adequate preventive procedures. As you can, if you were to read the Chapter 3, you can see that our case studies shows that the court will take into account the step taken by corporation in preventing the corrupt practice within the organizations, which is what we call commercial organization under the Act after the coming into force of Section 17A MACC Act. So as the corporations, as we know, have been given about 2 years prior to coming into force of the Section 17 Act to prepare themselves for the it is therefore, in my view, unlikely that the court will allow any commercial organizations to use COVID-19 pandemic crisis as an excuse for not taking immediate steps to put in place adequate preventive measures. Yeah, that's my view.
Thank you, Mr. Gan. What about the impact of corporate liabilities on companies, directors, and/or shareholders? Mr. Fu, can we pick your brain on this?
Let me deal with it from the aspect of a shareholder. Happily, if we're talking about Section 17A of the MACC Act, it has very little impact on the shareholder. So shareholders are relatively safe, because even the Companies Act, Section 1921, provides that a member shall not be liable for the obligation of a company by reason of only being a member of the company. Of course, if the shareholder decides that he wants to be a director as well, or he takes a management role, then the problem comes with the territory. Section 17A will catch him in that other capacity, but not as a shareholder. So as a shareholder, you're relatively safe. I suppose if the company is penalized for breaching or for falling foul of Section 17A, then ultimately it's the pockets of the pocket of the company that will be hit. Or shall I say, ultimately it's the pocket of the shareholders that will be hit. But that aside, the personal liability, none. Right? I think Gan will deal with it from the aspect of the directors.
Further from what Joon has said, right? I think that's all about shareholders. But insofar as directors and companies, of course, it is very clear under Section 17A that the moment the associated persons committed the bribery act, that is with the intention to give, or promise to give, or even agreed to an offer to give. So the moment that bribery act is being committed, then there will be a corporate liability imposed upon the corporation as well as the directors. So in this regard, it is therefore very important that we bear in mind, Section 17A applies to two categories of corporations. There's one, local incorporated corporations with business in or outside Malaysia. And second, foreign incorporated corporations with business in Malaysia. And the corporate liability under Section 17A of the MACC Act is extraterritorial in nature, in the sense that it applies to all corrupt act of the associated persons, be it committed in or beyond Malaysia, wherever in the world, and in relation to its business wherever in the world, so long as it is for the benefit and advantage of the commercial organization. It is very important to bear in mind, Section 17A only applies to outbound corrupt act. That is when you give as opposed to when you receive. There is a very clear difference here. And the other thing to note is that the corporate liability under Section 17A of the MACC is a strict liability offense, where proof of mens rea on the part of corporations, and even for that matter, director is in a way not required, although under the sections, as we further explained in Chapter 3 of our book, there is certain statutory provisions that is applicable to director in the sense that whether or not at the point of time he's confines of the act or connived of the acts or otherwise. So as Joon said, ultimately when the corporate liability is being established, it is the financial aspect of the corporation that will be affected, because if convicted, the commercial organization will face a fine of not less than 10 times the amount of the bribe, or a prison sentence of not more than 20 years will be imposed. So according to the Companies Act 2016, any officers of the company, including directors and the company secretary, are liable to serve the prison sentence on behalf of the companies. So that tells the significance and the very heavy burden imposed on the corporations. This all is with a view so that we can create a corruption-free culture, and therefore lift the level of our corporate governance to another higher level. And I think this is what the intention of the company, and also you can see from the various steps that has been taken by the Security Commission as well as the Bursa Malaysia. That's I wish to share, Amanda.
Thank you, Mr. Gan. I really like how you're always tying the topics back to the chapters of the book. I think we'll move on to our next segment, which is corporate rescue mechanism, a very crucial topic. As many of us know, the pandemic and multiple movement control orders have exerted stress to many company businesses and they are suffering losses. How can companies recover from COVID-19 in terms of the options for corporate rescue mechanisms that's available to them? Mr. Fu, do you want to try?
Let me take this first. Thanks, Amanda. Well, there are, broadly speaking, 3 mechanisms available to companies for corporate rescue. The first, not in any particular order. The first would, of course, be the corporate voluntary arrangement scheme that is contemplated by the sections following Section 395 of the Act. Then you have judicial management, which is a slightly more tedious process that starts. I will deal with that shortly, and you will also have your scheme of arrangement, which is something that has been in place for a while now. That is now provided for in Section 366 of the new Act. What I'd like to talk about a little bit more would be the processes for judicial management, or the mechanism for judicial management. Now, judicial management has been the subject of quite a number of recent decisions of our High Court. And I think it's still as far as case law is concerned in Malaysia, it's still in its infancy. We draw a lot of our authorities from abroad. You will see that mechanism, a fairly elaborate mechanism for judicial management set out between Section 403 and 430 of the Companies Act. Now, there are exclusions. It doesn't apply to certain companies licensed by, for example, Bank Negara and under the CMSA. And under our Act, an application for judicial management can be taken out either by the company or by the creditor. What it entails is for an application to be made to nominate an insolvency practitioner as a judicial manager, that assuming that order is granted. And there have been quite a number of cases where that judicial management order has not been granted, or when I think there was one instance at least it was granted and it was set aside subsequently. Now, but the point is, when a judicial manager is appointed, he's got a time frame to come up with a statement or to come up with a proposal as to how the affairs of the company will be addressed. Now, why does he have got to do that? Now, a judicial manager's role, or rather a judicial manager, comes into the picture for the reason that precisely for the reason that the company is unable to pay its debts. So instead of having a situation where the company is wound up, which is obviously a very drastic remedy, an option is available for either the company or creditors to put in place the judicial manager to come up with some sort of a scheme to preserve the company as a going concern, and to save and to preserve the ability of the company to pay its creditors rather than being wound up. So once a judicial management order is made, there is a moratorium that is put in place. Under our Act, I think it's a 6-month moratorium period, and it can be extended by another 6 months. And what happens during the moratorium period? Essentially, it keeps creditors at bay. No winding up order can be made against the company. I think it also provides, if I'm not mistaken, the Act also provides that a resolution to wind up the company cannot be made. And as with instances of liquidation, when an order is made to appoint a judicial manager, there's a clawback period of about 6 months, if I recall correctly. Any transactions which essentially dissipates or removes the assets of the company might be caught. So that is, broadly speaking, the regime of judicial management. And I think Gan will speak to you about corporate voluntary arrangement and what that entails, and you'll see the difference between that and judicial management.
Mr. Gan, over to you.
If you can hear what Joon just said, I think the one that is very striking is about the moratorium period. I think essentially that is what is most important at this point in time, because every businesses need a breathing space so that they can restructure their liabilities, and so that they do not run the risk of getting into liquidation or being sued and having a judgment hanging over their head. Of course, our COVID-19 Act, as to the certain act, has helped to ease away this financial distress and burden from some of the businesses. But this corporate voluntary arrangement, in fact, is another statutory mechanism that provide a very economical and speedier mechanism for a financial distress company to rehabilitate its business as a going concern. Because you know why? Because as opposed to some other mechanism, for example, scheme of arrangement, in this CVA, corporate voluntary arrangement, the moratorium will automatically commence from the time the requisite documents for the proposed CVA are submitted to the court. And that period will remain in force for a period of 28 days and can be extended for a maximum period of 60 days with the consent of nominee, as well as the approval of creditors and members at their respective meetings. And as we say, during this meeting, corporations are safeguarded from all, from among others, being wound up. It will not also be subject to legal proceeding, executions, or distress, unless, of course, ordered otherwise by the court upon application by the creditors themselves. And as we say, this moratorium would enable corporation time for its proposed CVA to be considered and approved by the creditors and members. And once approved, the CVA will take effect and binding upon all creditors of the corporation, irrespective of whether they have voted in favor of the proposal. So the obvious difference between CVA and the judicial management mechanism, as Joon just said, is that for the entire process of CVA, there is no court approval is required. From the time from its submissions of the paper to the court, its approval by the creditors member of the corporation, as well as the implementation, no court proceeding and court order is required. So that is the very economical mechanism which in appropriate circumstances ought to be used and applied by the corporations. And Amanda, as you say, stay tuned with chapter 6, because all these
chapter 6.
Of the books. Thank you.
So what are the, as a follow-up question, what are the practical considerations that have to be taken into account before deciding on the corporate rescue mechanisms to revive businesses?
Let me take that.
Mr. Gan?
I will take that, Amanda, since
Okay.
I dealt with that earlier question first. Now, as you have seen from what Gan and I have mentioned on judicial management as well as corporate voluntary arrangements, they require different things and they give us different things. The same can be said of the scheme of arrangement as well. So the practical issues that one will have to look at in deciding which scheme that which rescue mechanism that they would like to apply for would generally be these. How prepared is one to go to court? Obviously, going to court entails costs. So when you talk about a CVA, for example, there's generally no requirement to go to court unless you want to avail yourself of the moratorium. Whereas as far as judicial management and schemes of arrangement, you've got to go to court. And when you go to court, that's sometimes when all hell breaks loose. That's when lawyers come in. That's where a lot of legal fees are spent and earned. The next factor that we should look at is what happens to the control or management of the company. So you would have heard from what Gan said that when a CVA comes in, when there's a CVA, the directors still remain in control. Of course, there's a nominee who's put in place to supervise. Whereas in judicial management, the judicial manager steps into the place of the board. Now, I'm aware of a recent decision of our High Court, I think it was our KL High Court, which says that the directors or the board is retains residual powers. The judicial manager's power is only to a certain extent. My understanding of the provisions of the Companies Act may not necessarily be consonant with that, because I seem to recall that the Companies Act provides that the judicial manager takes over the board or steps into the shoes of the board. Whereas if we're talking about a scheme of arrangement, the directors will still remain in place. The next factor would be the availability of a moratorium. Of course, all of them come with a moratorium in one way or the other. Some are automatic, some are not. But the key difference, I think, is in the length of the moratorium. So with a CVA, you've got an automatic moratorium of 28 days. As I've said earlier, as far as the judicial management is concerned, you've got 60 days and that can be extended. Sorry, I think it's insofar as the scheme of arrangements, you've got 3 months, the last I checked. As far as judicial management is concerned, it's 6 months, not 60 days, and that can be extended for another 6 months. Whereas for the others, the CVA, you can extend it for 60 days, if I'm not mistaken. Gan can correct me if I'm wrong. And as far as a scheme of arrangement, it can be extended for further 9 months. So those are generally the factors one will look at. Of course, for us as lawyers, it also depends on who is instructing us, because the person instructing you is a person who's seeking the the imposition of the mechanism. So if the director is the one who's approaching you, then you of course have access to all three. But if it's the creditors who are approaching you to come up with a mechanism, then I think you're reduced to either a judicial management or a scheme of arrangement. So those are the factors that I can see. I'm not sure if Gan has anything to add to that.
I think you have put it quite succinctly, but I think Amanda, just give me 1 minute. I just want to say one sentence. Is that if the so-called scheme arrangement involve various classes of members or creditors, I think based on the existing statutory structure that we have, I think the more appropriate correct mechanism would be scheme of arrangement under section 366 as opposed to CVA. But of course, and one also for that purpose can start with the applying under judicial management, and then thereafter for the judicial manager to then proceed with the scheme of arrangement under 366. And that would basically be a very good practical approach, particularly when the corporation also needs a moratorium period to be effective in India, because under judicial management, it would be effective the moment the application is filed. Yep, that's something that I need to add. Amanda, thank you.
Okay. Thank you, Mr. Gan, Mr. Fu.